Good afternoon, everyone joining us today for this installment of the Hunt Institute's Post-Secondary Pathways webinars. We will give attendees just a few more moments to log in, so we'll give folks about 2 minutes, and then we'll get the webinar started. Thanks for being here. Thank you for those of you who are just logging on. If you're just joining us, thanks for being here. Feel free to use the chat to drop in where you're from, name, location, anything that you want panelists and participants to know about. But we'll give folks about 30 more seconds and then we'll get started as folks trickle in. Well, excellent. I see lots of folks coming in from all over the country. I know a few more folks filing in, but thanks again for joining us for this May installment of Post-Secondary Pathways. My name is Dr. Winn. I'm our Deputy Director of Higher Education, and happy to moderate this discussion today about Title IX policy. Before we get started, just want to do a few housekeeping reminders for everyone. We do have closed captioning, so feel free to turn that on should you want that. We're also streaming on Facebook Live right now, so if you want to follow along on Facebook or share afterwards. We'll also post this on, I'm hearing someone say there might be an echo. Am I getting echoes from other folks? Nope, just one. Okay, so good. Just wanted to make sure it wasn't me. Great. Well, we'll also post this on YouTube for anyone to see after the recording's done. And then finally, we'll create a session, a session key takeaways guide that we'll post on our blog and share any resources that might come up today. Today's conversation, like I said, is going to be about the past, present, and future of Title IX. I'm excited for this conversation. I want to just give a couple of framing remarks before we dive into the conversation with our resource experts. But just quickly, Title IX protects people from discrimination based on sex in educational programs or activities that receive federal financial assistance. This is over 17,000 local school districts, over 5,000 post-secondary institutions. It includes charter schools, for-profit schools, libraries, museums, vocational rehabilitation agencies from all 50 states, District of Columbia, and territories of the United States. So Title IX is broad-ranging and has effects all across the country. It was enacted as part of the Civil Rights Act of 1972, and at that time, women earned just 7% of law degrees and 9% of all medical degrees in 1972. Today, they earn nearly half of all law and medical degrees. So Title IX has had an extraordinary impact on the education of women, but also on women in sports. As Title IX rules have evolved, though, there's also been an increased focus on conversations around sexual assault, including reporting and prevention. And Title IX makes all universities and colleges disclose resources available to survivors of sexual assault, including medical care, emotional support, and legal services. As I wrap up, I just want to note there's a common misconception on college campuses that Title IX really only affects undergraduate students. But that's not the case at all. It supports and protects faculty, staff, visitors, graduate students, everyone on the campuses. We've had changes under the Obama administration, then the Trump administration, and now more under the Biden administration, including a recent rule proposal in the past week or so. So we're going to have a very interesting conversation with this, and I'm excited to have some research, policy, law, and advocate perspectives on this panel. So let's go ahead and get started. Panelists, thank you for being here today. Dr. Houston, I want to come to you first. You're the Title IX Coordinator and Director of Equity and Compliance at Adelphi University. You hold a bachelor's degree in liberal arts from Harvard and a JD from Suffolk Law School. And one of the things we talked about was your role in the previous Title IX writing recommendations and rules. So we appreciate you being here. Like I said, you were cited in the U.S. Department of Education Office of Civil Rights Source Authority in May 2020 for the Title IX Final Rules regulation. Can you speak to us a little bit about your role in Title IX rules and the history of Title IX and what it means on a college campus?
Certainly, and thank you for the wonderful introduction. So, it's a really great starting point that we're talking about Title IX today. As you know, the new proposed rules were recently released, and they'll be out, sometime in May. So we're looking forward to those new rules. But as we think about where Title IX is going, we have to learn, also keep in mind Title IX history. Certainly, we understand that Title IX was established in June of 1972 under the Nixon administration. And certainly the number of rapes occurring across college campuses, certainly before that time and certainly after that time, we begin to see, in terms of the expansion of the interpretation around Title IX, that expansion, of course, grew over time. But I think one common concept around Title IX we should all keep in mind today and certainly moving forward is notice. How does notice, that the idea of notice around Title IX, how does that play into the evolution of the rule? So if we think back to, again, 1972, creation of the rule, we look back to 1986, the murder of Jean Cleary. What did we know on campus reporting crimes? We think back to 2011, Penn State. Who knew what and when? Notice. Moving forward, DCL 2011, and then of course the 2020, the final rule. So the common thread of all this between Republican administrations, Democratic administrations, is the issue in the evolution of notice. So that's, certainly my message today is, thinking about that concept, how does it play? And also, where's it going? What does it mean for the incoming rules? Later on this year, how will the notice be expanded or potentially contracted? Coming up later on this year. So that's sort of in a nutshell. Title IX law and policy over the past 50 years or so. But I think that the common thread, of course, is notice.
Yeah, thank you for that, Dr. Houston. And I'm sure notice will probably come up a couple more times in the conversation as well today, but appreciate that foundational understanding to help kind of ground us in the work. I want to come to you next, Skye. Skye David is the staff attorney at the North Carolina Coalition Against Sexual Assault. Skye's done some academic work on domestic violence that actually led to an undergrad research award and served as her foundation in her time at the North Carolina General Assembly. Skye, thanks for being here today. Can you tell us a little bit about the work you do at NC Coalition Against Sexual Assault to serve individuals and organizations?
Yeah. Hi, everyone. I am so happy to be here. As Winn said, I'm Skye David, and I have been the staff attorney at NC CASA for about 5 years. And during that time, I have really focused on our 3 prongs, which are advocacy, education, and legislation. I really kind of center myself in those 3 facets of work, and we represent all of the rape crisis centers across North Carolina. So in an individual capacity, if they need legal help. And also I do direct services to survivors, and I've participated in about 50 different Title IX hearings at institutions across North Carolina. I just take those on a rolling basis. So I've really worked with a lot of young people in Title IX hearings as well.
Awesome. Scott, I'm going to ask you a follow-up really quick. I'm just curious. We talk a lot about Title IX as federal litigation, federal policy. Can you just maybe give us an overview of what policy about Title IX looks like at a state level?
Yeah, so in general, the state does defer to federal Title IX policy. There have been proposals in North Carolina and in other states to go above and beyond what the feds have recommended, however, or in this case mandated. But none of those have been enacted into law in North Carolina at this point. So right now we just defer to those rules, and then the campus communities can make their rules based on the federal law and then kind of go above that if they choose to do so.
Awesome. I appreciate that. I think that's helpful context, particularly with a lot of the state level policy people on the call. So thanks for that. Awesome. Well, next I want to come to Montoya Hosing, who serves as partner at Ackerman LLP in Atlanta. Thanks for being here today. Montoya does a lot of work with providing training to clients involving discrimination, harassment, student accommodations, Clery Act compliance, and FERPA as well. Vast litigation experience around defending clients against Title IX litigation. Montoya, thanks for being here. I appreciate you bringing your experience. From your legal experience in the Title IX, especially as it relates to athletics, can you tell us more about that work in Title IX around athletics and some best practices you've seen in ensuring equity and compliance?
Sure, Winn. Thank you for having me on the panel, and welcome to our guests that are here. As Winn said, I serve as outside general counsel to a number of higher ed institutions across the nation and assist with a variety of topics, including Title IX, sexual misconduct, and the athletics context. Since Dr. Houston and Scott spoke about Title IX and the sexual misconduct context, I'll speak a little bit about athletics. So Title IX, from an athletics perspective, requires schools to, one, offer male and female students equitable opportunities to participate in sports. Two, it also provides male and female students with equitable benefits and services in their athletic program. That simply means making sure that female and male students are provided the same services and equipment and things like that within their athletic program. And finally, Title IX requires schools to give female and male students their fair share of athletic scholarship funds. So it has to be proportional to the number of students that are playing sports within each particular sport. A few best practices for institutions to implement to ensure equity and compliance with Title IX athletics. And this is just a few. There are definitely way more than this. But one, institutions should regularly survey their students to gauge the interest in a particular sport. This may provide some insight into possible sports to add to your institution's program, or even to take away, because if there's not a lot of interest in a particular sport, then those resources can be pivoted to other sports that your student body is interested in. Second is to perform an athletic equity audit. And this means examining your athletics program to determine its current compliance with Title IX. That means looking at the equipment and supplies provided to each team, travel and per diem allowances, publicity given to your teams, making sure the men's basketball team is not receiving more publicity than the women's tennis team, among other things. And should probably come as no surprise to many on this call today, but a majority of schools are really out of compliance with Title IX. So institutions should be sure to hire outside counsel to perform these audits for the added benefit of attorney-client privilege, because if we prepare a report that analyzes your Title IX compliance, that can be shielded in the attorney-client protection, and which means that it's not discoverable if there is any litigation that comes from it. And finally, it's no surprise that communication is one of my best practices. You just have to talk to your student athletes, coaches, and athletic administrators about what's going on. They usually know what's going on in campuses. They have a good pulse on what issues may be present there. So these are just a few tips to help people on your campuses when you get back there in order to make sure that everything is on the up and up with Title IX compliance.
Yeah, thank you for that, Montoya. You know, I think one of the most visible examples we've probably seen recently was the NCAA men's and women's basketball tournament. I believe that maybe that was 2021, that you really saw a stark difference in everything from accommodations to the gym. And I know there's a lot more with NCAA and all that, but that's just one of the things I think about. Um, Before I come back to Dr. Houston, I want to ask you a follow-up, Montoya, but I want to remind the audience, we have a Q&A chat function. Please make sure to use that. Montoya, someone asked how schools define sports. They particularly were asking about like as esports are emerging, but I'm also thinking about like club sports and Division I sports, Division III. Like maybe is there anything you want to add about just like what is technically a sport and how do schools kind of navigate that?
Right. Well, it makes me think because there are several different levels of sports. There are club sports, there are intramural sports, there are actually, sports, varsity sports for each institution. And so it really depends on the athletic skill that's involved, the competitiveness, if there are different people within your conference that actually participate in that same type of sport in order for it to be classified as a sport on campus. So there are, very technical legal definitions as to what a sport is, but as far as elevating sports to that varsity level, there are things that a school needs to take into consideration to make sure that it fits in that box.
Makes sense. I appreciate that. And we've got some great resource experts on here if any of the institutions out there are interested in more of these conversations as well. Excellent. Well, I want to come back to you, Dr. Houston, really to get back into this conversation around due process and evidentiary standard of proof. I know that's come up a lot, particularly in the changes in recent administrations. So can you tell us more about your research work around evidentiary standard of proof? Whoa, butchered that one. Sorry about that. And can you tell us more about that work and what you found in some of that research?
Certainly. So, I think a good place to start would be the Dear Colleague letter of 2011. We know that within that document, it was suggested, it was certainly mandated, of course, that preponderance of the evidence would be the standard for colleges and universities to use determine whether some sort of violation has taken place under federal law. So the research that I conducted in the number of years, over about a period of about 3 or 4 years, showed that while schools were able to, and by the way, if you're not familiar with the preponderance of the evidence standard, of course, that means simply more likely than not that the violation took place. So what we were able to find is that, of course, that while schools were able to implement the preponderance of the evidence standard, what we're able to find is that some faculty groups were protected by a clear and convincing evidentiary standard. And so what happens is that the investigation will be conducted under a preponderance standard, but the decision will be determined under a clear and convincing standard. And what we found is that it created an unfair balance across the country in terms of various faculty groups, the CBAs, that certainly codified the standard. So what that meant, of course, is that the students were held to one standard while the faculty was held to a different standard. So the research showed that some schools, were able to mitigate that problem, but for the most part, there was an unfair balance with regard to how we adjudicate these matters on campus. So in the end, the research showed that it was unfair to have that standard set in place. This viewpoint and this research was actually adopted under the 2020 rules by the DOE. And so this is why now currently the current rule is that when it comes to students, faculty, and staff, the evidentiary standard must be the same for faculty, students, and staff. So I think that certainly, yes, it's, we know what the law is, the preponderance of the evidence versus clear and convincing, but it's really about how we apply that rule across the campus that makes it fair or not. So I'm very proud and humbled for that research, but there's more work to be done. around due process, around my current research, of course, involves labor unions and intersection of labor law with Title IX. This is called the, essentially, the flashpoint here is the duty to bargain. When schools determine what that evidentiary standard actually is, can the school decide that matter unilaterally, or can they must include the union, of course, in that decision? So this is, again, a matter of potentially state law, but also around application of the rule on the campus. It's one angle. It's a sort of a very unique angle to Title IX research. But in the end, as I kind of mentioned in my first segment, that as we've gone from 1972 to, of course, DCL 2011, the current 2020 rules, we're always moving and evolving towards fairness. Is it fair to have notice? How much notice is actually fair? Notice and opportunity, due process, 5th and 14th Amendment. But when it comes to this issue now is moving forward around the duty to bargain, this also is an issue of notice. This also is an issue of how fair it is on campus, how it's enforced versus faculty and staff. So it's so large, such an important topic that I wish I had more time to discuss it. But in the end, due process is at the foundation of Title IX, and it should be at the foundation of Title IX. My fear, of course, is that moving forward with the proposed rule, that due process may not be protected so much under these incoming rules. That's my view. That's not my school's view. That's certainly my view. So I want to make that clear. Just, but I think that I think in the end, whether we agree with it or not, notice must be protected. Notice must be enforced, and due process has to be at the core of how we apply Title IX enforcement.
Yeah, thank you for naming that. And my colleague Julia Orange-Hoffman just dropped in the chat some of that research that you've done, Dr. Houston. So if folks want to read more into that, I know there were some things that if you're in the audience, you're not super familiar with Title IX, things like preponderance of evidence is probably something that you haven't heard before. I worked in fraternity and sorority life for a decent amount of time before this. And I think that was a conversation we had oftentimes is as we're thinking about things like this, I think there's an assumption that due process might look exactly like it looks like in the courtroom. And it looks a little different, not a little, it looks a lot different on college campuses and how they kind of do it. So Dr. Houston, I may come back after we get to these other questions and talk a little more about what that process looks like on campus for individuals, but I'll go to the other folks and then we'll come back and talk about that a little more. But Scott, I want to come to you next, and you started to hit on it when I followed up about state laws around Title IX. And you've done a lot of work around domestic violence prevention and laws around that, and that all kind of weaves together. So when you're having these conversations, but how do you partner with government officials, with electeds to inform legislation around these topics?
Yeah, thank you for that question. So where we start as an organization is that we survey our members to see what issues they're seeing with survivors that come in their doors every day. Our rape crisis centers are in all 100 counties in North Carolina, so they're really the closest to seeing what needs survivors have. And we survey our members. We also listen to the survivor groups that we have at NC CASA that say, I went through this criminal process, and these are the things that didn't make sense to me or I think should change. And then there's always some court cases that have made a ruling or maybe suggest that the General Assembly here in North Carolina or anywhere change some language in order to get a desired result. So one great example of that was that we had a law from, well, not a law, we had a court ruling from the 70s. It was a 40-year-old precedent, and it remained on the books as precedent because we had not changed the law. In 2019, we successfully passed that after years and years of trying, and it was around consent. And withdrawal of consent, we were the only state left in the nation where you could not withdraw consent once a sexual act had started. Now, to decide how to partner with legislators, you have to meet folks where they are. And so what I really try to do is sit down with a legislator and talk to them and see, maybe they're uncomfortable with talking about sex or sexual assault, and that is completely normal. So I don't try to push anyone. And if something resonates with a particular legislator, then I will ask them, like, how would you feel about running this bill or putting this provision into something else? And that's really kind of how I start my process with that particular issue. People were really uncomfortable with it, and it was hard, particularly in a generational aspect. The younger generation of folks seem to really understand how this would happen, but older folks really did not. And I had to reframe the way I was communicating that to people, and really kind of go back to the beginning and create a narrative that older folks could understand and be able to grasp and say, yeah, that makes sense. We should allow you to withdraw consent once an act has started. Additionally, we work with the college systems in North Carolina, particularly the UNC system. I maintain regular check-ins with the UNC system just to talk to them about some issues, if there are Title IX issues at their schools, maybe some policy gaps that I see when litigating these cases, or just in reviewing policies, and how we can get to a better place with, if there are gaps, or if a survivor sees something at a particular school that we feel needs to change.
Yeah, that's great. And I'm glad you brought up the 2019 law. I was hoping you would. If you weren't, I was going to shout it out, Neil's work on that after this question. But I appreciate you naming all that, and particularly about, withdrawing consent. I remember I worked in student affairs for quite a while, and the conversation, I remember it shifting from no means no to yes means yes, and this idea of affirmative consent and some of those conversations around it. And so just appreciate you bringing it to the personal level when you're sitting down with legislators and folks working on this, because we also see that be the best way to influence the conversation and help people truly understand why this is an important conversation to have. So thanks for all your work. Montoya, I want to come back to you, as we've kind of talked about sports some, and one of the huge things around sports is name, image, and likeness policy right now, particularly at the college level. So can you tell us a little bit about how you've seen institutions of higher ed navigate creating NIL, and are they updating their Title IX policies in concurrence while they're doing some of that work?
Thank you, Winn, for that question. I'm saying at institutions in drafting these policies is that they look closely at NCAA rules, conference rules, and state law with regard to their particular NIL policies, and then try to align their policies as closely as possible to those requirements, because there's several players at issue when it comes to NIL. It's not just the student athlete in the institution, but as I named before, NCAA, your conference rule, and your state law rules. As we all know, Florida and California were some of the front runners on this. So an institution has to take all of that into consideration when drafting their specific rules or policies around NIL. But one thing we have to remember is that NIL is so new. That means that, rules and regulations are constantly evolving. So institutions have to keep abreast of these new developments and changes in the law. That's why it's important to have, compliance personnel in place. And also, outside counsel to make sure that your school isn't running afoul of any, new rules or issues that have come out. There have been recent changes with regard to boosters association with student athletes. And because there is so much gray area. It never hurts to make a call to an expert in this field to make sure that everything passes muster, and one thing that we saw from, the Cavender twins and University of Miami is that the NCAA is actually looking into these NIL rules and making some enforcement decisions regarding them. So institutions have to keep in mind and making sure that they are in compliance with NIL and all the rules surrounding it. As far as policies, Title IX policies being updated along with NIL policies, I have not really seen that. And I think it's likely due to the fact that Title IX regulations are kind of in flux right now, as we mentioned before, is that we expect the new rules to be finalized and to come out next month. And as you mentioned, right at the beginning of this call, is that there was just a new rule, under the current administration, their proposed rule regarding transgender athletes. So everyone is sort of operating on a wait and see basis. And then once the final rules come out, I expect there to be policy updates across the board with Title IX and NIL, and people going into their athletics departments and also their Title IX offices and figuring out how to handle these new rules and these new changes and operate from there. So.
No, I appreciate that. And, the conversation around NIL is going to continue to evolve and morph as we think through it, particularly watching, Vanderbilt comes to mind, but how they pulled their NIL money for students. And I'm curious to see where some of these things go over the next several years. So appreciate all your work on that. Just want to remind folks, we're going to open it up to Q&A for folks. So if you have any questions, feel free to drop them in there. Montoya, I saw you unmute. Did you have something else you wanted to add quickly? I just want to make sure you got everything.
Well, I just wanted to add with your comment with regard to pooling money, there are things that are, some institutions have collectives, which, serve as a way to support student athletes, on a larger scale. But to your point, NIL, it's always changing. It's the wild, wild west, which makes the work that I do fun at times. So
yes. Absolutely. Well, I want to jump into some of these questions. I saw someone in the chat asked about what NIL is. The Hunt Institute, we just dropped a link in there for you about a conversation we had last year. But long story short, it's the ability for athletes to use their name, image, and likeness. There were some rules in place that kept them from monetizing that and stuff, or even really doing much with their name, image, and likeness in NCAA. So excited to see some changes there to support that. Dr. Houston, I want to come back to you, and then I'm going to kind of bring a similar question to Skye. I want to come to you, Dr. Houston, to talk about this conversation around evidence, preponderance evidence, and where we think the future is going. And Skye, I'm going to pose the similar question to you, but maybe thinking about it on the survivor advocate side. What do you need in a space like that to be a good advocate for survivors of assault or someone trying to right a wrong that Title IX policy? So Dr. Houston, we'll come to you first, and then Skye will follow up with you.
Okay, so I think we have a good understanding at this point of the preponderance of the evidence versus clear and convincing evidence. Well, we've talked about preponderance, but what is clear and convincing, right? It's certainly a choice that universities can make. And in my estimation, it's almost ironclad evidence that something has in fact occurred, a violation of Title IX law has occurred. How easy is it to achieve that on a college campus between emails, text messages, voicemail messages, social media messages? How possible is that to achieve? And I would say that I won't say it's impossible to achieve, but it's very, very difficult to achieve. So that's why I think that when it comes to fairness, when it comes to due process, do I think that the preponderance of the evidence standard is probably the most effective standard? That's certainly for each institution to decide for itself. But I think that no matter what is chosen per institution, certainly there must be notice of that rule. But I want to touch upon one important thing as well, because we talked about preponderance, we talked about clear and convincing. I'll mention one more aspect as well. In the incoming rules, there's also this language about the Title IX coordinator serving as the decision maker as well. Is that due process? So, due process is an incredible concept. It's really broad, and it discusses, it involves many different things. Yes, it involves the evidentiary standard, but in terms of who's making the decision, I have a concern that having the same person serve as investigator and decision maker is certainly causes some concern. Here's why it is a concern. Again, going back to my research, do you know that years ago, even before DCL 2011, that there were schools doing investigations that had a 0% responsibility finding? That means that every person that came through their office, they could never find through all the rapes and sexual assaults and pictures and evidence and video, they couldn't find any evidence of sexual assault. There are schools who had a 100% responsibility finding, which meant that every person that came through their school, they always found sexual assault on the campus. So do we think that's due process? No. I think a due process is a thorough investigation based upon the facts, driven by the facts. And that's what lets us know what due process is and how it is to be affected on campus. So keep in mind that one thing, of course, how we're choosing the evidentiary standard that we're using is key and vitally important. But in terms of who's deciding that, making that decision is also very, very important. And again, my fear is that with the incoming rules, it will return to those days where the person investigating the matter is also the person making the decision. Then we're going to return to the days of 0% responsibility findings.
Yeah, I appreciate that, Dr. Houston. And maybe after give Skye a chance to talk, Montoya and Dr. Houston, we can talk a little bit about, how do we train people to do these investigations? Who are these people doing investigations, stuff like that? But I want to come to you first, Skye, really about being an advocate for survivors. What do you need in the space to be a good advocate? And yeah, what can we learn?
Sure. So when I am interviewing a survivor for the first time, one of the things that I always say to them is, if we lived in a perfect world, what would happen? And I try to sense what their goals are and see how we can edge towards that goal. Maybe not get there all the way, maybe get 70% of the way there. Maybe their goal is just to be in different classes than the respondent. And in Title IX hearings, the person who makes the complaint is called the complainant, and the person who is alleged to have committed the conduct is called the respondent. So maybe they just want to be in a different class. Well, you don't need to probably go through an entire Title IX investigation and a hearing process to get that. The school has to provide some reasonable accommodations to the students. And so that's probably something that can be achieved pretty quickly and ensuring that student safety. But when we're looking at a full investigation, it is difficult. As Dr. Houston said, on campuses, there are a lot of different factors at play. And one of those is oftentimes the use of alcohol or drugs, and incapacitation is at the center of the case. I would say probably 80% of the cases that I have worked on have some bit of incapacitation in the overall case. So when there is incapacitation or intoxication, and does it reach the level of incapacitation, you also have to think about that standard of proof for that. And that is a central part of almost every case, where we're trying to decide whether or not the student had had enough to drink, enough people saw how much they had drank to decide that they were drunk or incapable of making decisions to the level of intoxication. And if they are at that level, does that mean that they were able to consent to any sexual conduct? And that is really where a lot of my work centers around, those sorts of issues. But I would say that as far as like a preponderance of the evidence standard, it's certainly a lot easier to get there than it is to get to a clear and convincing evidence standard. And we do have some schools in North Carolina that use clear and convincing evidence. And just to be a realist with my clients, I like to tell them from the outset, it's going to be very hard for us to get to that level and prove that in a hearing. But I'm gonna try, and it's my job to do that. But just talking to survivors and letting them know what is coming, because the Title IX investigation process and the hearing process are also pretty traumatic, and it can be really stressful on both, I would say, complainants and respondents. So that's something I try to take into consideration as well.
I really appreciate that, and for naming that the process itself can be a traumatic experience for individuals in, having to relive the experience in terms of telling it again, talking to friends and even family about it. So appreciate you naming that. Montoya, I guess I want to bring this conversation where we're kind of going to you. One of the questions I'm going to kind of merge, one of the questions we got from the audience was, can an attorney represent someone accused of sexual violence in a Title IX hearing? And then I want to, open it more broadly. Who are doing these investigations? Our college campuses are not, a deputized police force. Like who is doing this work on campus?
Right. Great question. Under Title IX, each side is they can obtain what's called an advisor, and your advisor can be an attorney. So, some of my clients, my institutions, the clients that I represent, they have had the issue of, okay, well, if we as an institution have a responsibility to provide, advisors to each party, do I have to pay for an attorney? And that's not the standard under Title IX, but, if a respondent obtains, a lawyer as their advisor, what responsibilities does that place on the complainant? So that's often an issue that my clients deal with. So to answer that question, yes, a respondent or a complainant can have an attorney serve as their advisor. There are rules around their participation in the actual hearing and things that they can do, but an attorney can be present in the process. As far as training individuals to participate in these investigations, I've seen my clients do it in a few different ways. One, the Title IX coordinator gets it in, and they have people on staff that serve as Title IX investigators, and they go out and they perform the investigation. Some clients don't have that luxury of having staff to do that, so they'll either hire, an outside firm or a third party to do those investigations. I regularly do investigations from my clients. Because of that single investigator model, it's so troublesome, as Dr. Houston pointed out, having that separation between the person who does the intake, who does the investigation, who makes the final decision. So institutions I've helped institutions conduct trainings on how to do a proper investigation. So I think the key to all of this is making sure that people on your campus are educated about A, what their actual role is, and then B, given the tools in order to make sure that they're doing their job to the best of their abilities.
Thanks for that. And, I think it's so critical to name some of that as student affairs professional. We did a Clery training once a year or so, and that was it. And, there was then some efforts to try to do additional training on identifying Title IX violations and things like that. So we've still got a long ways to go. And I think particularly student affairs, the turnover we have is also a problem. It's constantly retraining, it's constantly re-educating. And with the shifting policies and rules, it's that constant professional development and learning about it. Dr. Houston, I want a similar question, bring it back to you, because one of the things that we've talked about I believe some changes have happened between whether or not the respondent is in the room at the same time as the other words escaping me, but just what does that space look like, and how can administrators ensure that it's a safe space to have a conversation to collect all the facts so that they can make an informed decision?
I just want to be clear, your question you're asking during the investigation stage?
Yes. During the investigation, how are they?
Yeah, I think that I think that certainly at Adelphi, we're very liberal when it comes to certainly having the investigator present, the advisor present, but as well in terms of asking vitally important questions. So I think your question goes to whether they could be in the same room or not. Is that yeah?
That's where I
So,
was going.
yeah,
I believe it changed. Like at one point in the Obama administration, you couldn't be in the same room, and then the Trump administration, you were supposed to be in the same room. But maybe I'm off on this. So was just curious some of the murkiness of the rules, where we're at with some of that.
Yeah, I'm not as familiar with that side of the law, so I don't want to speak to the issue too deeply. I'm sure Montoya or Skye has a better answer than I would.
Well, and I saw Skye. I'll come back to you, Dr. Houston. I saw Skye kind of do a hand, so maybe Skye,
Sure.
if you want to chime in on it quickly.
Yeah, prior to 2020, the school could make reasonable, they could have both students in separate rooms come into the room with a decision maker for their questions, and the other party's attorney could come in and they could kind of shuttle in and out. I also had hearings where there was a sheet in the middle, so the parties didn't have to see one another. But with the 2020 rules, all parties have to be seen and heard at the same time. So because of that, a lot of those hearings post 2020 have been on Zoom, so that's not super difficult. But in the room, I've had some live hearings since 2020, and all parties have been in the room.
That's great. That's super helpful. I think then that's where audience member that was asking was trying to kind of get to. But Dr. Houston, just back to the investigative process. How does that work, and how are we supporting administrators in that work?
Well, I think it's really up to the Title IX coordinators to, of course, enforce the policy as it's written on campus. Of course, the federal rule as well as the local university policy. So I think that with proper training required under Title IX, that really can be accomplished. But one of the wrinkles that comes up here are some of the emerging issues around Title IX. So, for example, the intersection between Title IX law and neurodiversity on campus. These are, again, emerging issues that we're seeing on the campus. And just to speak to that one concern, certainly, many schools have taken great strides to make their campuses much more inclusive of various groups on the campus. But of course, we can't have separate rules for various groups. So what I've seen in my colleagues across the country is that particular issue around neurodiversity intersecting with Title IX. Montoya or Skye, have you seen that concern as well?
Personally, I have not seen that. My clients have not come to me with that issue, but I can certainly see how, efforts to make sure that you're being inclusive could make some others on campus feel uncomfortable or discriminated against. So I'm sure I'll get calls right after this about this topic, and I'll be calling you, Dr. Houston, to help on this one.
Well, that's someone did ask kind of about affinity groups and, like Summer Bridge for women in STEM, things like that. And, this is an evolving conversation, and it's also going to continue to evolve, particularly conversations around affirmative action. These are all intersectionalities that are going to play out. I'll start to wrap us up. And so the final question, I'm going to come back to you really quickly, Montoya, with a question about training that someone asked. But for Skye, Dr. Houston, and then Montoya, I'll come back to you to close this out. I want you to think about what you want folks to know about Title IX. One of the questions someone asked was, is someone on campus, like, what should I be looking out for to make sure we're not in violation of Title IX? And so maybe I'll broaden that a little bit. What should people be aware of, or what are you optimistic about where Title IX is going? So I'll come back to that question. Final one about real content for you, Montoya, though. Someone asked what trainings look like, and you mentioned your time auditing some of these institutions and seeing like where they had gaps in Title IX work. What's a result of one of those audits? What do folks typically do training? How do they fill some of those holes that you're able to identify in that work?
Right. A lot of times, my recommendation would be for training, because a lot of issues really stem from people just do not know the rules around certain things. So training is always number one, like go back, policies. Make sure you have a policy in place, because a bad policy that is followed 100% of the time is better than a great policy that's only followed 50% of the time. So make sure you have policies in place for different things on your campus. Two, make sure people know and are trained on what the policies are, the policies and procedures, to make sure that they are being applied equitably across the entire campus. And even if you have multiple campuses, I have clients that have different satellite campuses, and sometimes we will see a completely different process on one satellite campus from the other, and that's an issue. So we need to make sure that your campuses are all aligned and on one accord. But as far as, training goes, make sure people are aware of the rules, they know what to do in this situation. And training is just not, hey, this is what the rule is. Like in my trainings, I incorporate role playing, I ask questions. It's very involved because sometimes these decisions will have to be made quickly on the spot. So you have to train your brain to make these decisions quickly. So.
This has been a great conversation. I probably also got a little heady or in the weeds at some point, but I appreciate all the audience that's been engaged with us. And there's lots of additional conversations that we need to have around this. But as we wrap up, just want to ask each of you, next 30 seconds to a minute or so, what are you optimistic about Title IX? What do you want people leaving this to know about Title IX as we're moving forward? So Dr. Houston, I'll come to you first.
Yeah, I would say as we're wrapping up, that this has been a great conversation. So I want to thank everyone on the panel. They've been great. What I would say is that, we talked about due process, talked about the evidentiary standard. One area that I want to bring up, and I hope that folks leave here with, is that as we're giving energy and rightfully so to sexual assault, dating violence, domestic violence, and stalking, I think at the same time, when it comes to retaliation, we must also give the same energy. When respondents or maybe a witness is involved in a matter, and they may be assaulted because of this, or harmed, or in some other way discriminated against, we should give equal energy to retaliation matters that occur on campus, as well as the initial sexual assault, dating violence, domestic violence, and stalking.
That's such a great point. We hadn't hit on the retaliation part, so I really appreciate you naming that. Skye, I want to come to you. What do you want people to know?
Sure. I'll just quickly say that, I am in sexual assault, so my focus is sexual assault. And what I would say is that sexual violence is a spectrum. There are things that could happen that are less harsh, and then there are very egregious acts. And so the way that campuses or K-12 institutions generally respond to that is going to be different, and it is always going to be a case-by-case basis. No matter what the administration, what rules come down, there are going to be differences in every case. I say every case has a gem, and there is a consideration made. And I would just think that all schools should be aware of what those rules are, what the federal rules are, and then where they have some wiggle room, because you have a tension between the university or the institution, the student's safety, and protecting themselves. So ensuring that you have a good tension there and that you are protecting your students for the safety of all people on campus.
Thanks for that, Skye. Montoya, we'll come to you to close it out.
Sure. What I would like people to remember is just remember what the essence of Title IX was for. It is the equitable treatment, of male and female students for institutions that are receiving federal funds, because I think we get so caught up on the term equal, and equal does not mean equitable. So people need to make sure that they remember that, and Title IX, I know it gets placed a lot in, the sexual misconduct, but there's Title IX in athletics, and so that is like a lot of of my focus too, and there have been big pushes, as far as, women and females in athletics because of Title IX and their participation in sports and making sure that they are receiving equitable treatment when it comes to sports. So I just want people to remember, like, let's go back to the essence and really remember what Title IX is all about.
Yeah, this has been a great conversation. I really appreciate it. And someone in the chat named for us to train more people than just administrators, because faculty are often on the front lines of some of this. And I just think that's another great flag for us, that it's more than just the student affairs administrators. The faculty are oftentimes realizing changes in habits or things that could be signs that someone needs support. So as we close out today, I just want to say thank you all for being here. We've shared some resources with you, but also there will be additional resources. I know this conversation has been a heavy one, so I also want to name that RAIN is a national organization that you can always reach out to. And then you've also got state-specific supports, and I'm always happy to help direct you toward those as needed. But as we close this out, I want to remind you that we'll be back in May for the next Post-Secondary Pathways webinar. We're going to be talking about higher education deserts, something that doesn't get a lot of conversation. And most people think when we talk higher education deserts, it's only rural spaces. And it is a lot of rural space, but we're also going to talk about some urban spaces that are higher education deserts. And then in June, we'll be back talking about supporting Latinx students on college campuses. So with that, thank you all. Appreciate everyone being here. Have a great rest of the day, and we look forward to having you next month. Have a great day.